If you've decided to file for the K-1 visa or are about to embark on this journey and are currently as confused as I was with so many questions running through your mind, I thought I'd create a video on some of the most common questions about the K-1 fiancé visa that you're probably wondering about. How can I expedite my case? Do you need to submit separate letters of intent to marry or just one? And when do you need the I-134? I did a lot of extensive research on the process, so I wanted to share as much as I can to make life a lot easier for you. Here are 15 questions that I've seen a lot of people ask in the forums, Facebook groups, as well as questions that were on my mind. Question 1. Which processing center will your case be sent to? All cases are sent to the California Processing Center. It doesn't matter which state the American citizen is from or lives in, they will all get sent to the California Center. I know the mailing address for the I-129F form is Texas, however, all applications are directed to the California Processing Center. Question 2. Can you visit your fiancé while waiting for the K-1 visa? Yes, you can. Waiting for the K-1 visa doesn't hinder your ability to travel to the US. It works in your favor as it shows that you're spending time with your partner and are in a genuine relationship. Just make sure that you don't overstay more than you're allowed. Additionally, you should have ties to your home country to show you'll be returning home in case CBP asks for it. An example would be a return ticket home. My fiancé visited the US multiple times during our wait for the K-1 visa, and we had no issues at all. When entering the US, he was asked how long is he staying for and where will he be staying. Just be honest with the CBP officer upon your arrival. Question 3. Do you need to hire a lawyer for the K-1 visa process? No, you don't necessarily need to. We did lots of extensive research through online materials and realized we could do the process ourselves. We realized that we'd be inputting our personal information into the form as well as compiling the required documents, which we felt competent in doing ourselves. A lawyer or third-party company would only ask for the same information, so we couldn't really justify the extra cost. Plus, using a lawyer or agency doesn't make the visa process any faster, nor does it guarantee that you won't get a request for more evidence. Question 4. What is the NOA1 and NOA2 and what do you do with it? The NOA1, Notice of Action 1, is a receipt that you've submitted your I-129F K-1 visa application to USCIS, and it's a letter in the mail you receive within 1 week of submitting your application. It will be sent to the American petitioner. You don't need to do anything with it. However, it will have your receipt number to track the progress of your case. The NOA2 is a notification that you receive again by mail that says your application has been approved and sent to the National Visa Center for processing. The petitioner, or the American, should make a copy of this and send it to the fiancé so they can take it along to their embassy interview. Keep both of these letters safe as you'll need them for future forms when you enter the USA on the K-1 visa. Question 5. Does the country you're from affect the processing time? The country you're from, whether it be France, Egypt, Australia, Canada, does not at all affect the processing time. USCIS tends to process cases in the order of being received, and the country in which the non-American fiancé is from isn't taken into account. Question 6. Which countries do you need a police clearance from? The beneficiary will need a police certificate from any country they've lived in for more than 6 months. In our case, my fiancé had lived in the USA for a year, so he needed to obtain a FBI clearance report from the USA. In addition, as he resides in the United Kingdom, he also needs a police certificate from there, as it's the country he resides in. Question 7. Do you need to propose or officially be engaged in order to file for the K-1 visa? The answer is no. You don't officially have to be engaged in order to file for a K-1 visa. As long as you have the intent to marry within 90 days of entering the USA, it is sufficient. Question 8. What happens if you forget or don't have a specific document they require during the visa interview? If you, for whatever reason, forget to bring a specific document to the embassy interview, or don't have something that they need, your case won't be rejected, but you'll need to provide the missing piece. Normally, you'll be issued the Form 221G, which indicates that your application has been put on hold and further processing is required. Question 9. Do you need to submit separate letters of intent to marry or just one? When we researched the K-1 process, we saw that you had to submit separate letters of intent to marry, which had to be signed and dated. In our case, we submitted a third just to be extra careful, which was signed and dated by both of us. Question 10. What are the reasons you may get a RFE, request for evidence, while waiting for your NOA2? One of the reasons you may get a RFE is that you've forgotten to sign parts of the application which require a signature. Some other reasons may be that USCIS needs more information from you, such as further evidence of the 2-year meeting requirement, any documentation showing criminal convictions, or just evidence of your intention to marry when entering the USA. Question 11. Do you need to submit original documents when filing the I-129F? Absolutely do not submit original documents with your I-129F application. USCIS only needs photocopies of your documents and more than likely will not send back any original documents you send into them. Just as a side note, I highly recommend making a photocopy of your entire I-129F application so you have a backup copy of your form. Question 12. How can you expedite your application? In short, you cannot expedite your K-1 visa application with USCIS. On the USCIS website, they have a section that shows you the circumstances under which you're allowed to make an expedited request. But in short, this only really applies if you're in the military or for emergencies and urgent medical humanitarian reasons. USCIS will expedite your case if it benefits the petitioner, and these reasons don't apply to the beneficiary. So for example, even being pregnant doesn't qualify as a reason to have your application expedited. Unfortunately, there is no process to pay a fee and have your application expedited. Question 13. When do you submit the I-134? The I-134 is a form called the Declaration of Financial Support, and it is filled out by the American petitioner, i.e., in my case, me. It's basically a form that shows I can financially support my fiancé when he comes to the USA. There is no cost to this form, and it doesn't need to be mailed in anywhere. This form is taken with the non-American fiancé to their embassy interview. As a side note, the form only considers the petitioner's financial information. So even if my fiancé was employed or unemployed, it really wouldn't make any difference towards the immigration process. Question 14. What is the current processing time of the K-1 visa? As of today, the current processing time for a K-1 visa is approximately 9 to 11 months and approximately 6 months for new cases filed from today's date. The processing time is constantly changing, but USCIS is definitely speeding up their processing time. Question 15. Who needs to attend the interview for the K-1 visa? The only person who needs to attend the interview is the beneficiary, i.e. the non-American citizen. In most cases, the American petitioner won't be allowed to enter the embassy for the interview. I'm sure you probably still have a lot more questions on your mind, but I hope this video answered a few that you may have had and helped clear your mind just a little bit. If you have any more questions, please feel free to drop it in the comments and I'll try to answer them as best as I can.